Hello, everybody, and welcome back to my English law channel after an absence of a few months. Anyway, so this is going to be about the law of property, and obviously pertains to England and Wales, but much of what I say will be applicable to all Commonwealth countries. Anyway, there are two main types of land from a legal perspective in England and Wales: registered land and unregistered. And this is a fundamental difference, and we'll go into the Land Registration Acts and so on. And there are different rules which apply to registered land and unregistered. About 90% of all land is registered title. That's registered land. So unregistered is becoming less and less relevant and may well disappear in a couple of decades' time. So you've got to know whether you're dealing registered or unregistered land, because the rules can be totally different. Anyway, so land law is quite tricky. I find it the hardest, and some people like the fact it's mostly statutory, though there is a bit of case law you would need to know. It's quite historic, and land is vital because everybody utilises land. You live on it, you shop on it, you drive on it, you walk on it, you work on it, and even if you don't use it directly, use it indirectly. You need farmland somebody else is using to grow food and so forth. And what land will always be here, okay, can sometimes be washed away and be under the sea. So it's a thing which really has most value, although its value can go up and down. An acre of land can have vastly different values depending where it is. Location, all that. Now, the Human Rights Act 1998 took effect in October 2000. That was quite important. That was incorporating the European Convention on Human Rights and Fundamental Freedoms into UK domestic law. And one of the things it's got is the right to family life. Now, some people who are living illegally on land then said that they couldn't be evicted because it'd be disrupting their family life, and they sometimes won their cases when they started building illegally. The squatters' rights, which we'll come on to. So whenever you're considering a piece of land in law, there are four questions you should ask, and in this order. Is it registered or unregistered land? Second of all, what interests may exist in the land? By interest, I mean people who have some legal or equitable right over that portion of land, but don't actually own it. And the third question is, are these interests either legal or equitable? And it's very important to get the difference between law and equity, but we'll come on to that. It's very tricky. And fourth of all, what action has been taken to protect any of these interests? Because some interests can be overriding interests, and some of them can be overreached by the purchaser, and so on. So so there are a lot of statutes which are about this. So it's an issue of kaleidoscopic spiralling complexity. And the government has intervened more and more to regulate this, because one thing about land is they don't make more of it. And I know we can reclaim it from the sea, but that's exceedingly expensive. This is the only planet that is habitable. I mean, Trump had the genius idea of colonizing Mars. I really wish he'd go and live there, somewhere with no oxygen and no water. What a bright idea that was. Anyway, so there are private law aspects to land, as in that's one individual against another, or one company against another natural person against another natural person, as opposed to an individual or organization against the state. But public law is when the state collides with the individual or an organization, non-governmental organization, company, things like that, one state against another. We're looking at the private law aspect of it. Okay. So sometimes they're interested in land. How can we set up these interests? How can you transfer them to somebody you're selling it to, whatever? How can these interests become extinct? And how are these are enforceable? Because the enforceability against third parties varies very considerably. So there are some core principles for all lawyers to understand, even if you don't actually work in property law. Anyway, so we'll go through this topic by topic. Looking at the 1925 reforms, which were most significant. Because the First World War happened, and an awful lot of people got killed, and an awful lot of property changed hands, usually from an older senior generation to the junior generation of the same family. And of course, because there are some tax, there's death duty, some inheritance tax, unless you hand it over 7 years before your death, okay, to your heir. And so a lot of families, wealthy families, had to pay big inheritance tax. Sometimes they couldn't afford to do so. They had to sell it, and huge amounts of land was changing hands. So something had to be done about it. So there are important cases. For example, R. New Haven Port and Properties Limited against East Sussex County Council 2015. So this is about the rights of people to walk on the beach. Because can you register the foreshore of a beach the same way that you would a village green under Section 15 of the Commons Act 2006? By the Commons Act, we mean public land. We don't mean the House of Common. Commons are places like Clapham Common, Ealing Common, all over, as in publicly owned land, a park, like even in the United States, Boston Common. So people walking along the beach, did they need permission from the town council to do so, or was it a right they had? Well, any person's got the right to wander on public land, but was it like a village green that where sometimes you can be restricted in what you can do and you're not allowed to do, lighting a fire there, for example. This is a beach in Newhaven, Sussex. That's a county due south of London on the coast. There was a major harbour there, but that declined in importance through the 20th century. Now there are a few ferries from there. So anyway, so the town council of Newhaven decided that you required permission to use the beach. They weren't actually you didn't actually have to ask for each time, but it was subject to certain conditions, right? There were some provisos for using it. Yes, anyone can walk there, but with certain caveats, the things you're not allowed to do. Now, Oxford Street in London is the main shopping thoroughfare, the retail paradise, and it's actually owned by a borough council of London. London's divided into 32 boroughs. But is it really public property, this street? Because, hundreds of thousands of retail junkies walk it every day. So it might seem preposterous to think it's owned even by a borough council. But nevertheless, the Borough Council has the legal authority to close the road for reasons if they want to allow a demonstration through or something, or they need to do repair works, and there are bus stops there, and where the bus stops are positioned can be changed by the Borough Council. So when we go back to the example of the beach in Newhaven, perhaps it's wrong to think of it as being owned, but there are certain rules about what you can do and what you're not permitted to do, like drive your car onto the beach and things like that, in which case it's not completely public. Okay, so the public's use of land makes people think that nobody owns the land, but that's not true, because the property title can be owned by some local government or indeed national government, and that's what the Supreme Court decided in this case. So if someone has the legal authority to make rules concerning a portion of land, then that suggests that it's not completely publicly owned. It's not owned by the whole nation. It might be owned by that borough council or whatever. So sometimes you're only permitted to use land through the permission of the landowner. This is not expressly granted. He doesn't have to give it to you orally or in writing each time, but it's implicitly given, and there's signs up, yes, you are allowed to come here subject to blah, 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 these conditions. Not dropping litter, for example. So there was a case called Blunton and Catterall in 1821. And in this case, it was decided that there was no common law right to walk along the foreshore, as in sort of below the high tide mark. Otherwise, in the Republic of Ireland, no one can privately own below the high tide mark in the Irish Republic. I don't know about in England and Wales. Therefore, the authority could make rules about that, about who could pick up shellfish there, for instance. So Newhaven Town Council need to be able to regulate the harbour because of ferries, saying you can't swim here because that'd be dangerous. You might get killed by a ferry might just swerve to avoid you and crash into something else. Anyway, so there are two axioms of the land law. So we're studying maybe private rights here. And these are often, as we say, is rights against the world to exclude anybody else. So anyway, it applies to trademark infringement and things of that nature. Private companies can own rights over their intellectual property. The law of property applies not just to land. Some of the principles are applicable to property of other natures. IP, a book you publish, a chemical formula you patent, and so forth. Anyway, it's an immensely complicated issue, this. There used to be a court of chancery, which is a court of conscience, developed in the Middle Ages when statute was too rigid and inflexible and couldn't cope with unforeseen situations and novelties. And therefore, the Lord Chancellor, he was the King's chief minister. There was no prime minister back then. He was often the King's confessor. Remember, England was a Catholic country back then, and so therefore he was keeper of the King's conscience. And it was about what was conscionable and unconscionable. If something was unconscionable, that we ruled against. So common law became more adaptable through equity. And it created a thing called an interest, whereby somebody could be the legal owner, but the beneficial owner would be somebody else who would have equitable rights rather than legal rights. Anyway, so the common law and equity had two separate courts, but they were amalgamated in the Judicature Acts of 1873 to 75. So every court these days deals with both law and equity. So equity, confusingly enough, is a branch of law, but it's a more informal branch. Come on to the particulars of it later on. We shan't delve too deep right now. So anyway, there are common law remedies which are awarded as of right. In the Middle Ages, in courts of equity, they said, "I shall not suffer a wrong to be without a remedy." The people had to be able to seek redress, and the courts of equity were going to rectify situations, even when the law of the land, with its strict and unimaginative application, wouldn't allow a proper remedy. Sometimes the courts simply had to say, "I can't make a decision because there's no statute on this." But the courts of equity were more inventive. But perhaps that's wrong. Some people see that as judicial activism and saying that judges shouldn't legislate. Anyway, so reforms occurred. Now, law and equity, the gulf between them is not as great as it used to be, but we'll come on to that. So there are various axioms of law that we've got to comprehend, but there is a distinction between legal and equitable rights to this day. So we know that if you have a legal property interest, that is what you'd expect. It's all written down, it's all very formal. It's a right that binds the world, okay? Legal rights bind the world. That's a key axiom to commit to memory. But let's look at equitable interest where the situation is more unclear. Courts of Chancery developed this. So if you have an equitable property interest, then you're saying that somebody apart from the legal interest holder has a priority over the legal owner in certain respects. So there's medieval use. Okay, a man goes off on crusade and he says to someone else, "Here, I'm legally giving the land to you. Please look after it for me. Use it for the benefit of my wife and children, and I'll come back in a few years." Sometimes he never came back, he was killed. Sometimes he did come back. But whether he came back or not, sometimes that person who'd been given this on trust, but that was the legal owner, "I'm not giving it back. And whilst you're away, I'm not using it for the benefit of your wife and children. I'm using the benefit of me. The rents from any profits I'm taking, I'm selling, keeping the money for myself." And legally, he was in the right because of the legal owner. So that was unfair. So the crusader was being ripped off. So courts of equity said this is unconscionable, and they created the legal concept of a trust, and a trustee has to use it for the benefit of the beneficiaries. They're the beneficial owners, the wife and children in this case, or the guy who went off on crusade and eventually comes back. So someone who's a transferee, who has it transferred to him, he's the trustee, and the transferor is the original owner who transfers it to the transferee or the trustee. Same person, transferee, trustee. Okay, so people had to petition the king and seek a writ, and then the Lord Chancellor was the one who dealt with the issue. So now is the transferee's conscience bound? Is he doing something which offends against conscience? And that's how courts of equity developed from sort of 1189, the First Crusade, onwards, has been used by the family. So they're all saying is equitable rights bind the world with the exception of a bona fide purchaser of a legal estate for value without notice. We call this person equity's darling, which is misleading. It's not to say equity prefers this person, but equity can't do anything to this person. This person's rights are unassailable. Okay. So we need to see that at the core of English land law, there are various types of property interests. There are equitable interests, and these used to be possibly defeatable. The owner of somebody who owned land, we often say owns Blackacre in these hypothetical examples, gives somebody else an equitable interest over Blackacre, for instance, a restrictive covenant saying that you can't do this or that on the land, or an interest behind a trust, which is hidden, not on the land register. Sometimes an equitable easement, the right to do this, to walk across it, to park a car on it, drainage right, something like that, to graze sheep. And that equitable interest would be destroyed when it was sold. Okay, when Blackacre was sold to equity's darling, but not if it was sold to someone who wasn't equity's darling. So the owner of the equitable interest would have the right extinguished. So remember, equity's darling, this is the bona fide purchaser of legal estate for value without notice. Without notice means not knowing about these equitable rights. So could you just amalgamate all property interests, legal and equitable? Well, no, unfortunately, it's vital. That's how trusts exist. So that ain't going to happen. So we've got the legal title, and sometimes there's equitable title. And the trustees are supposed to manage the trust so that there is some benefit accruing to the beneficiaries. So the equitable beneficial owners, they're the ones who gain from it. That's the idea. So this is going to continue, this parallelism. So Section 1 of the Law of Property Act 1925 cites those rights which can be made legal, and there are certain formalities that have to be gone through to do that. Now, the Land Registration Act 2002 reduced the significance of this, but it still exists. The legal equitable divide still exists, despite being not as great as it used to be. Equitable property interests can sometimes be defeated. Okay, so we have to bear in mind that this is all very complicated. Yes, you want to use technical terms, but if you're answering questions, don't mindlessly trot out stuff about equities, darling. It's got to be applicable. Okay, so examiners aren't going to give you some marks for just vomiting information in the general direction of the question. It's got to be carefully crafted to actually answer a question. Pilcher and Rawlins, 1871 to 72, is a vital case here about equities, darling, and how that equity will only go so far, right? It's about the boundaries of equity. It's not about equity's generosity. That's often a mistaken thing. We often talk about the fourth generation of property, land ownership, and that's time. Because how long is it? How wide is it? How deep is it? Or how high is it? Because it goes underground, it goes above, up into the sky. But also it carries on. Land is always there, and it's in the same place. Unlike movable properties. This is immovable. Okay, so it goes back to the Middle Ages when there was a pyramidal structure, the king at the top and various barons below him in a few strata, right down to the landless peasants and the thralls at the plinth of society. So land could be divided up physically. And it applies to mining rights, as I said. So Bernstein and Skyviews, 1978, shows it's about airspace, but people can fly over your land as long as they're a reasonable height. What's a reasonable height? Come on to that some other time. Boccardo SA against Star Energy UK 2010 was a UK Supreme Court case about this. The SA is for Société Anonyme, as in as a company, is about how far below the surface property rights extend, and also temporarily, as in how long in time these go on for. Well, some land has been in the same hands, the same family for centuries. So, in principle, there's no end to this, although in the most strict technical legal sense, the Crown owns everything. Everyone has an interest in it, as in it's to your advantage that you have some control over it. So land cannot be got rid of. Okay, so as we say, land ownership is an interposed abstraction. That's what a judge called Rudgeon said. Anyway, so the Crown, in theory, owns everything and just delegates it to other people. So it's very, very complicated. There's fee simple absolute in possession, and that is the freehold estate of property forever. There's also term of years absolute, so that's leasehold estate, but we often call it a lease, a letting, a tenancy, or even a demise. Demise, very misleadingly, just means a lease. Okay, and that's for a limited period of time. It could be like 6 months, it could be 20 years, it could be even longer. So in Section 1.1 of the Law of Property Act 1925, there are only the two estates capable of existing at law, and if the formalities are conformed with when transferring them, they can exist in equity. There are different types of freehold estates. There's life estate, which lasts for the lifetime of an individual, a grantee. A grantor has granted it to a grantee. There's also fee tail, where the estate is subject to limitations about who can inherit the land, is often limited to males and actually from the father. Often it's patrilineal descent. It doesn't have to be spearside, it can be matrilineal. So it could even be about affiliation rather than affiliation. So now these such rights exist in equity, and that means that they're behind a trust. So anyway, that's enough. We'll come on to formalities next time. Goodbye.